Hello, my name's Nick Rowe. I'm the Head of Employment here at Lodders Solicitors. I deal with all things employment law. So in this blog I'm going to be talking about restrictive covenants and how they might be enforced. So a restrictive covenant can be used by an organisation to restrict the conduct of an employee or shareholder after they've left that organisation for a period of time. Commonly, the organisation seeking to enforce can prevent an employee from soliciting their custom and clients, from taking employees with them when they leave and or competing with the business. I'm often surprised by clients that make statements like, well, restrictive covenants aren't enforceable, are they? In fact, the opposite is true. If a restrictive covenant is drafted in a precise and limited way, it can be a really good tool for the business to protect its interests moving forward, and it can also provide a really effective deterrent to that employee from conducting themselves in breach of that restrictive covenant. So the benefits of a precise and well-drafted restrictive covenant are that it provides a very effective deterrent to the employee from acting in breach of the restrictive covenant in the first place, and it also provides the employer with a very effective remedy in the event that they do breach the restrictive covenant. If an employer or company feels that an employee or shareholder which has left the company is acting in breach of their restrictive covenants, there are a number of remedies open to that employer or company. So these remedies can include seeking an injunction, which is where the party seeking to enforce the restrictive covenant goes to a court and asks them to put in place an order which prevents that employee from continuing to act in breach of the restrictive covenant. Another potential remedy would be to bring a claim for loss, which would entail bringing a claim in the courts seeking compensation for the loss that has been caused by the conduct of the employee in breach of the restrictive covenant. Another potential remedy would be a claim for inducement to breach, which would be a claim against the employee's or former shareholder's new employer in the event that they've encouraged them to breach the restrictive covenant. The best advice, I think, is to really understand the client's commercial objectives and to only really restrict the conduct that they feel would really hurt their business. In so doing, I think the best thing to do is always get advice early. If you'd like to get in touch with me in relation to anything that I've talked about in this video blog, then please do feel free to get in touch at any time.